So not because you entered the property and didn't have the intent to hurt or injure or prevent the owner from using his property, but simply because you didn't damage the property. So that's what the majority would say, and the loser would then win the case at this stage, and that would become case law. You might have concurring opinions which say, you know what, loser? I agree with the majority that you should win, but I have a different reason. I agree with your reason. I agree that if you trespass on someone's property without that intent to prevent the owner from using that property, I agree that that is what the public policy holds. That's what the common law in this state agrees upon. Well, they're still going to, their numbers, these judges' numbers that agree to the concurring opinion, will still go toward the majority. So the loser will still win, but they'll have a different reasoning behind it. And it's, at this stage, there's a lot of information I'm going over today. It's just an overview. So don't get frustrated or nervous about what you're learning. I'm giving you an overview so that you have an idea of what we're going to go over this semester, and that you'll at least have heard these terms once before we really jump into things. So occasionally you might hear the term slippery slope argument. I'm sure you've heard it used before. A slippery slope argument is a logical fallacy. A logical fallacy. It assumes, or the person using that is usually using the slippery slope argument to say that public policy shouldn't change because if you do this for one case, then now we're going to have to apply it for all cases. Slippery slope arguments are a fallacy because that's not the case. It never is the case that one case will suddenly cause a domino effect onto all other cases, related or non-related. But people use it as a scare tactic. Well, you can't approve this because this just starts a big boulder rolling that's going to, the earth's going to end. It usually goes to some ridiculous end that that it's unnecessary to go to, or that it's illogical to go to. But you might hear it occasionally. Aside from case law, you'll hear the term restatements occasionally. The restatements of torts is sort of a model code that is published to simplify what most states consider, or the majority of states consider, to be the law on a specific tort area. So they'll define battery, assault, larceny. They'll define the torts in the restatements in the hopes that states will adopt through statute the restatements. And it's actually dependent on a lot, even in case law. You'll see judges quote the restatements as a secondary source, as saying, I'm not just the only one that thinks this way. Look, the restatements show it as well. So you might hear restatements. And there are different restatements. There's restatements of contracts, etc. know that when we're talking about torts, we're talking about civil court as opposed to criminal court. In a civil court, we have a plaintiff, and this is the symbol I use for plaintiffs, and a defendant. That's the symbol I use for defendant. The plaintiff, again, is asking the judge to do something to the defendant. Defendant needs to pay or do something to remedy the situation. Versus a criminal court where you have the prosecution, the state basically. The prosecution represents the state. Asking a court to find the defendant criminally liable for some action or inaction. These deal with crimes, misdemeanors, felonies, that sort. Civil court deals with everything else. Contracts, torts, real property, anything that's not a crime. Here you're talking about punishment. Here you're talking about restitution. Making someone whole. Here, someone might have been murdered, so there's no way to make someone whole. Rather, you're going to punish the person. You're going to incarcerate the person. You're going to fine the person. You might even kill the person, the death penalty. So in criminal court, we're talking about putting someone in jail, fining them. This could be a speeding ticket, for instance. You wouldn't sue an individual for speeding. You would sue an individual for ramming into your car because he was speeding. But the state is the body that gets to prosecute a person for breaking the law, for doing something that is prohibited by statute and for which there is a criminal penalty imposed. Now again, in civil court, you have real property, you have contracts, and you have torts. Contracts are more trying to get the person who breached the contract to make the other party whole as if the contract had been completed, versus torts where you're talking about payment of pain and suffering, where you're talking about punitive damages, punishing the person for doing something so bad, or economic damages, lost wages, that sort of thing. You'll notice in the book they talk about the evolution of tort law. I'm not going to talk about that in class, just read about it in the book. It's interesting. Okay, now we're going to jump to chapter 2. Again, I would like to mention if anyone has any questions on any of this. Again, we're just overviewing the material. But if anyone has any questions, email me or post something on the discussion board. Most of the discussion boards are graded, so make sure you do put something on there. And you can check whether or not they're graded by simply